argument in the appeal, Knauer and the Minister of Justice.
Mrs. Knauer died tragically early at the age of 46, leaving behind a widower and 3 children. She had contracted mesothelioma through exposure to asbestos during her employment by the Ministry of Justice as an administrative assistant at Her Majesty's Prison, Guy's Marsh. The Ministry of Justice eventually admitted that it was legally responsible for her death. The dispute is about the way in which the compensation payable to her dependents under the Fatal Accidents Act 1976 for the loss of her income and services should be calculated. This may seem a dry and technical matter, but it is important to a large number of families who are wrongfully deprived of the income and services of a family member. Where a person is wrongfully injured or killed, compensation for future loss of money or money's worth is calculated by first arriving at a sum which represents the annual value of what has been lost. This is known as the multiplicand. That figure is then multiplied by the number of years for which the money or money's worth would probably have been received, had the wrong not been done. This is known as the multiplier. Where such losses are caused by a non-fatal personal injury, the court calculates the value of the losses between the date of the injury and the date of the trial and awards that as a lump sum for past loss. It then calculates future losses from the date of trial using the multiplier/multiplicand method to convert them into a further lump sum. In fatal accident cases, however, 2 decisions in the House of Lords had held that these losses should all be calculated from the date of death rather than from the date of trial. The main reason given was that in a non-fatal case, the court knows what has happened between the injury and the trial, whereas in a fatal case, it does not know what would have happened had the injured person not died. In this case, the trial judge held that he was bound to follow those decisions, even though, left to himself, he would have followed the same approach as in non-fatal injuries and calculated the future losses from the date of trial. He granted what is known as a leapfrog certificate, so that the case could bypass the Court of Appeal and come straight to this court, where it has been heard by a panel of 7 justices rather than the usual 5. The date matters because the number of years to be used as a multiplier, which is based on predictions of life expectancy, is reduced for 2 reasons. The first is for what are often called the vicissitudes of life, the chance of premature death or other reasons why the loss might not last so long. The second, however, is because those future losses are converted into a lump sum which is paid long before the income or services lost would otherwise have been received. It is therefore more valuable to the recipient. The problem with calculating the multiplier from the date of death is that it is reduced for early payment even though the lump sum is not in fact received until after the trial or the case is settled out of court. This means that in most cases, the family receive less than the sum which will fully compensate them for what they have lost, insofar as money can ever do this. In this case, the parties agree that it has made a difference of more than £50,000 to the compensation payable. The aim of an award of damages in cases of wrongful injury is, so far as possible, to place the person harmed in the position in which he or she would have been had the wrong not been done. Full compensation, no more, but certainly no less. This court, therefore, has no hesitation in concluding that it should depart from the earlier decisions of the House of Lords and adopt the same approach to the assessment of future financial loss in both fatal and non-fatal cases. Since those earlier decisions, it has been accepted that the assessment of future financial loss should be based on actuarial tables, known as the Ogden tables after the committee which produces them. This has made the calculation of a multiplier a much more exact science than it was before. These tables now include fatal accident calculations based on the date of trial. From them, it is also possible to calculate the likely losses between the date of death and the date of trial, thus reducing the uncertainties which had troubled the House of Lords in the earlier cases. This appeal is therefore allowed. Mr. Knauer is entitled to the sum which the parties have agreed would be payable on this basis. The court is now adjourned.